Welcome to our tutorial lessons on the law of torts. This is episode 10. You may recall that during our 9th episode, we treated the tort of conversion. In this episode, we are moving to another branch of torts, and we are looking at the defenses to international torts to person and property, mistake and inevitable accidents as the area of law under torts. Remember that the intentional torts referred to are all the torts treated under trespass to person, namely battery, assault, unlawful arrest, false imprisonment, malicious prosecution, and then the rule in Wilkinson and Downton. The defenses of one's property covers the torts of trespass to land, trespass to chattel, detinue, and conversion. Today we are going to identify the major defenses that will avail a person in a tortious action against him. Let's start by looking at defenses against intentional torts. Commencing, we will first look at the defense of inevitable accident. The principle for this defense, as laid in Fowler and Lanning, is that there would be no trespass if the injury to the plaintiff, though the direct consequence of the act of the defendant, was caused unintentionally and without negligence. It means that the absence of the element of intention will set free the person against whom the action is brought. The next defense is consent. Under torts, we will refer to this defense as volenti non fit injuria. This is a common law doctrine which states that if someone willingly places themselves in a position where parts might result, knowing that some degree of harm might result, they are not able to bring a claim against the other party in tort. In Hegarty and Shine, the court in applying this defense stated, as a matter of law, an assault implied an act of violence committed upon a person against his or her will, and that's as a general rule. When the person consented to the act, there was no assault, but that if the consent was obtained by the fraud of the party committing the act, the fraud vitiated the consent and the act became, in view of the law, an assault. Another instance where the defense of consent came up is the case of Latta and Bradell, where a doctor examined the patient on her own submission. Justice Bramwell said, very likely plaintiff thought defendant had a right to have her examined, but the truth is she submitted to it. She may have submitted under an erroneous notion of law, but it was not through fear of violence or coercion. In explaining the extent of the consent which ought to be given, the court stated in Beattie and Lingworth that consent must relate to the act complained of. Tacit consent. This defense is also known as voluntary assumption of risk. Therefore, note that volenti applies only to the risk which a reasonable person will consider them as having assumed by their actions. And from the case stated, if there is an act of fraud, then the consent given will not be a defense because fraud vitiates all. See the case of R and Williams. The next defense is self-defense. For a defendant to succeed under this defense, he must show that he committed the trespass in order to 1. Defend himself. 2. That in the circumstances it was reasonable for him to do so. And 3. That he used reasonable force. In Cockcroft and Smith, Holt CJ said, self-defense would be a justification to an action in trespass if the force used is reasonable, and in a case of trespass, one should not give violent and unreasonable return. The self-defense must be proportional. The court in Lane and Holloway reaffirmed this defense by saying, though self-defense is permissible, it must be reasonably commensurable with the attack which it presupposes. The fourth defense is the defense of the person of another. We will be pleased if you could tell us in the comment section the principle on the fourth defense and support it with an authority. Let's now look at the defenses available in defending your property. The defenses available could be classified into 5, namely, the use of reasonable force as a defense of one's property. 2. The defense of necessity. 3. Abatement of nuisance. 4. Mistake. And 5. Discipline. Let's now examine these 5 defenses. 1. The use of reasonable force. Generally, a person may use reasonable force to defend land, or chattel in his possession against any person threatening to commit or committing trespass to the property. But if the threat is not imminent or has passed, force is not justified. The principle is illustrated by Creswell and Searle. In that case, the plaintiff's dog and another dog chased the sheep in a field at night, and as a consequence, several of the sheep aborted. The defendant, to whose father the sheep belonged, went into the field, thinking the dogs were fierce and wild and that it would not be safe to catch hold of them, shot and killed the plaintiff's dog when it had left the sheep and was coming towards him. The plaintiff sued for trespass to the dog. The county court held that the defendant's defense failed because the dog had stopped attacking the sheep at the time he shot it. The defendant appealed. The appellate court held that the test applied by the county court judge was too narrow. The proper test per Scott LJ should be: the onus of proof is on the defendant to justify the preventive measure of shooting the dogs. Has, by proof, to establish two propositions, but each proposition may be established in either of two ways. 1. That at the time of shooting, the dog was either A. actually attacking the animals in question, or B. if left at large, would renew the attack so that the animals would be left presently subject to real and imminent danger unless renewal was prevented. 2. That either A. there was in fact no practical means other than shooting of stopping the present attack or preventing such renewal, or B. that the defendant, having regard to all the circumstances in which he found himself, acted reasonably in regarding the shooting as necessary for the protection of the animals against attack or renewed attack. Therefore, from the case in summary, the first test a person should rely on is that there must be an actual or imminent attack on the property, or that if nothing is done to prevent the attack will be renewed against the property. And in summary, the second test a person should rely on is that there was no other practicable means other than the means used in preventing the attack on the property, or that by acting reasonably, the circumstances in which the person found himself, that means used, was necessary. You may also see the case of Bird and Holdbrook, where the plaintiff, in raising the defense on one's property on the ground of reasonable use of force, failed to satisfy the test above. The second defense is the defense of necessity. An example of a case where this defense became relevant is the Mouse's case, where the action failed because the plaintiff's goods were thrown overboard in necessity. The court laid the principle as follows: in the case of necessity, for the saving of the lives of passengers, it was lawful for the defendant, being a passenger, to cast the casket of the plaintiff out of the barge with the other things in it. However, if the ferryman should overload the ferry, it is a valid defense in such circumstances as above for any passenger to cast things out of the barge, and the ferryman will be liable to the luggage owners for the loss of their goods, for it was his fault and not the fault of the passenger. But where the danger is as a result of an act of God, example a storm, then everyone ought to bear his loss. Therefore, it could be said that the defense of necessity comes in where there is the need to save life or destruction of one's properties, or where there's an act of God such as a fire outbreak, flood, among others. From the case of Kirk and Gregory, it could be said that the reliance on the defense of necessity of one's property must be in good faith and must be reasonably necessary. See also the case of Cope and Sharp. The third defense is abatement of nuisance as a defense. In the case of Lemon and Webb, one action was brought against the defendants for trespass because he cut the branches of the plaintiff's tree. Justice McNaughton held that, I think it is clear that a man is not bound to permit a neighbor's tree to overhang the surface of his land, however long the space above may have been interfered with by the growth of the tree. Nor can it, I think, be doubled that if he can get rid of the interference or encroachment without committing a trespass or entering upon the land of his neighbor, he may do so whenever he pleases, and that no notice or previous communication is required by law. The decision of his lordship thus means that a person was not under a duty to seek the permission of a tree owner. An occupier could lawfully remove those branches of his neighbor's tree that projected above his own land and interfered with the growth of his own trees. The fourth defense is the defense of mistake. We would be glad if you could tell us in the comment section the principle established in the case of Armstrong and Shepherd and Short for the defense of mistake to avail a person. The last defense is the defense of discipline. In relying on this defense, the principle as established in Ryan and Fields and Arnaud is that a person must ensure that the act relied on to discipline the other must be a reasonable one, which must not exceed reasonable and lawful coercion. This is the end of the 10th episode. We hope you learned and you will join us for our next episode on the law of tort. Please help us share this channel to everyone, like our videos, comment and subscribe. Thank you.